Welcome to the lesson on the primacy of EU law. As usual, the learning materials for this topic can be found in the description below the video, in order of appearance. The doctrine of primacy is one of the foundations of the European Union legal order. Its roots lie in the early case law of the Court of Justice, beginning with Van Gendon on Loos, where the court described the European community as a new legal order, distinct from ordinary international law. As soon as the court recognized that EU rules could have direct effect in national legal systems, the logical next step was the question of their hierarchical status. If EU law does confer rights on individuals that national courts must enforce, it follows that national legislation cannot simply overrule EU norms whenever a conflict arises. This logical progression took explicit shape in Costa v. Enel, a decision that has since become the cornerstone of the doctrine of primacy. In Costa, the court reasoned that the effectiveness of EU law would be undermined if member states could override EU obligations through domestic legislation, however framed. Direct effect, established a year earlier in Van Gendon, implied that EU provisions must be enforceable in national courts. For that enforcement to be meaningful, those provisions must prevail over conflicting national rules. Costa therefore stands as the court's first clear statement that EU law must take precedence over domestic law. The language used in Costa is remarkably firm. The court did not present primacy as a matter of political preference or pragmatic necessity, but as an inherent feature of the legal structure created by the treaties. This marked a decisive conceptual shift. Primacy was no longer an interpretive tool, but a defining characteristic of EU law itself. This reasoning was taken a major step further in Internationale Handelsgesellschaft. Here, the court declared that EU law takes precedence even over national constitutions. This was a striking extension of the Costa principle. If primacy were limited to ordinary legislation, member states could avoid their obligations simply by enshrining conflicting provisions at constitutional level. Craig and de Búrca remarked that the court therefore asserted that EU law must prevail, irrespective of the status of the conflicting national measure. In doing so, the court openly rejected the idea that national constitutional norms could limit the effect of EU obligations. The rationale remained the same as in Costa. Without unconditional primacy, the uniform application and effectiveness of EU law would collapse. Nevertheless, this dimension of the doctrine has attracted significant criticism. Craig notes that both academics and national courts have expressed concern that giving EU law superiority over national constitutions constitutes an unacceptable intrusion into domestic sovereignty. The next major development came in Simmenthal, where the court clarified that EU law cannot be displaced by later national legislation. This point may seem obvious, but it was essential for reinforcing primacy. If a member state could pass new domestic laws to override EU rules, primacy would be meaningless. In Simmenthal, the court held that any conflicting national measure must be regarded as automatically inapplicable. National courts are therefore required to disapply domestic provisions that conflict with EU law, even if those provisions remain validly enacted under national constitutional procedures. For many member states, including the United Kingdom, this raised profound constitutional questions. Dicey's classic formulation of parliamentary sovereignty held that Parliament can make or unmake any law, and that no person or body may override an act of Parliament. Yet the Court of Justice was effectively instructing national courts to do exactly that. This tension emerged most clearly in the UK through the Factortame litigation. In that case, the domestic courts accepted that they were obliged to disapply inconsistent acts of Parliament while the UK remained a member state. Although constitutionally controversial, the judgment demonstrated a practical acceptance of primacy in the UK legal system. Member state reactions: acceptance, conditional acceptance, and resistance. Not all member states have responded to primacy in the same way. As Trstenjak observes, national approaches fall broadly into three groups. First, some member states, such as the Netherlands, accept primacy without reservation. Craig and de Búrca also note that the Dutch constitution expressly recognizes the superiority of EU law, and Dutch courts have never expressed constitutional objections to the doctrine. Secondly, some member states accept primacy in principle, but impose conditions related to the protection of constitutional identity or fundamental rights. Germany is the most prominent example. The German Constitutional Court initially resisted the idea that EU law could override constitutional guarantees of fundamental rights, as seen in its early Internationale Handelsgesellschaft judgment. However, once the level of rights protection at EU level improved, particularly after the development of general principles of EU law and later the Charter, the German court accepted that it would not review EU measures against the basic law, as illustrated in Wünsche Handelsgesellschaft. Despite this, Germany preserved the theoretical supremacy of its constitution. This is evident in later decisions, including Brunner, where the German court asserted its right to review EU acts should they breach the fundamental constitutional structure of the basic law. Germany therefore accepts primacy only insofar as the EU remains within the limits of the powers conferred upon it. The third group consists of member states that reject primacy where it conflicts with their constitutions. The most forceful recent example is Poland. In its 2021 judgment in case K321, the Polish Constitutional Court held that several provisions of the Treaty on European Union were incompatible with the Polish constitution. The court argued that certain treaty provisions allowed the EU to exceed the powers Poland had transferred, and that they effectively permitted EU law to override the constitution and annul constitutional judgments. Schliephak and Bevan observed that this ruling directly rejected the unconditional primacy asserted by the Court of Justice. These constitutional confrontations are particularly striking in light of Declaration 17, attached to the Treaty of Lisbon. In that declaration, all member states collectively affirmed the principle of primacy as articulated by the Court of Justice. This affirmation included the reasoning of Costa and Internationale Handelsgesellschaft, meaning that all member states accepted primacy even over constitutional law. Yet, as recent events demonstrate, constitutional courts remain capable of challenging that principle. The tension between judicial independence at national level and the demands of EU uniformity leaves residual uncertainty. Despite widespread acceptance of primacy in practice, cases such as the Polish judgment show that challenges to its scope continue to arise. In conclusion, as the Council Legal Service recognizes, the principle of primacy is indispensable for the functioning of the EU legal order. Moreover, Saddle argues that from Costa to Simmenthal, the Court of Justice constructed a doctrine designed to ensure that EU rules are applied consistently and effectively across all member states. Yet primacy remains one of the most contested aspects of EU law, particularly where it intersects with constitutional identity and national sovereignty. While many member states, including the UK during its membership, accepted the practical necessity of primacy, others maintained that their constitutions set the ultimate limits of legal authority. The recent Polish judgment suggests that controversies surrounding primacy will persist. Nonetheless, the unique and sui generis nature of the EU legal system makes the doctrine unavoidable, since without primacy, the coherence, uniformity, and very existence of the EU legal order would be placed at risk. Thank you for your interest in this topic. For an extended analysis of the issue of primacy of EU law and explanation of applicable case law, check out our dedicated video. We hope that this lesson was helpful to you and are looking forward to seeing you again soon.